So today we are going to study the informed consent. So it implies an understanding by the patient of the nature of his condition, nature of the proposed treatment, rate of success of the treatment, all the risks and benefits involving the treatment, and if there is any alternative treatment available, and the details of that alternative treatment, and risks of not receiving the treatment. All these things should be included in the informed consent. The patient should be able to understand all these points. And the disclosure, all the disclosures must be in the language of the patient that the patient is can understand. The doctors have a legal, moral, and ethical duty to provide all relevant information that enables a patient to either accept or reject a treatment. So it is up to the patient that whether they want to accept or reject a treatment based on their understanding. Then there are exceptions to these. For example, emergency conditions and therapeutic privilege. We already discussed the therapeutic privilege in the previous video. You can check it out. Then we have informed refusal. The doctor has a duty to disclose all the possible risks of refusal to undergo a treatment. Means the doctor has to explain everything, every detail of that treatment to the patient, and it's upon the patient that it is on the patient to decide that whether they wanted to accept to the treatment or not. They can refuse the treatment anytime they want. After understanding, the patient can refuse to submit to treatment. Then we have a term called paternalism. So what does paternalism means? Paternalism, it is an abuse of medical knowledge so as to distort the doctor patient relationship in such a way that the patient is deprived of his autonomy or ability to make a rational choice. So here it means that it is any kind of act which disturbs the doctor patient relationship in such a way that the patient is unable to make any decision or any right choice. Autonomy means the right to choose, right to decide. So the patient is deprived of his autonomy or ability to make any rational choice. If the doctor doesn't disclose the facts and depriving the right of the patient to accept or reject the treatment, then the doctor may be sued under Section 350 IPC. If the doctor fails to disclose the facts and deprive the patient, the right of the patient to accept or reject the treatment, then he may be sued under Section 350. Then we have rules of consent. So it is very important to know what are the rules uh, involved in taking consent. So, first is consent is necessary for every medical examination. Okay, except for the routine general physical examination, which the patient implies on himself only. So, consent is necessary for every medical examination. Next, we have oral consent should be obtained in presence of a disinterested third party, example nurse. So, whenever we are trying to get any kind of consent from a patient, it is advisable to do that thing in front of a third party so that the patient cannot allege um, the doctor in a wrong way. So then we have third point, we have written consent is not necessary in any case except in court if necessity arises. So written consent is not always necessary. If it should refer to one specific procedure and should be in proper form and suitably drafted for the circumstances. It is not necessary unless you are expressing something in court, and that too in response to a specific procedure. Then we have the fourth point says any procedure beyond routine physical examination like blood transfusion, blood collection, operation, etc. requires express consent. What do you mean by express consent? It is also explained in the previous video. You can check it out. Then we have the fifth point. It says that the doctor should explain the object of examination to patient and the patient should be informed that the findings will be included in a medical report. And that's it. The point itself, it's explainable, you can understand. Then we have the sixth point. In medical legal cases, the doctor should inform the patient that he has right to refuse to submit to examination and that the result may go against him. If the patient refuses, he cannot be examined. Then the seventh point, it says the consent should be free, voluntary, clear, intelligent, informed, direct, and personal. Okay, Then the 8th point says, in criminal cases, the victim cannot be examined without their consent. The court also cannot force a person to get medically examined against their will. Okay. So in section 53, 9 point, section 53 CRPC, it says that a person is arrested if a person is arrested on a charge of committing an offense and an examination will provide an evidence as to the commission of an offense, then the doctor can examine such person by reasonable force if the examination is requested by a police officer of rank not below the sub inspector. So it means that if a person is suspected of committing a crime and it is seen that the examination will prove his criminal work, then the doctor can examine the person by force against their will, if under the request of a police officer. The rank should not be below the sub inspector. Examination includes collection of nail clippings, blood stain, blood, sputum, semen swabs, etc. In case of a female, the examination should be done only by under the supervision of a female registered medical practitioner under the section 53 to CRPC. And section 54 CRPC says mandates compulsory medical examination in all cases of arrest by police. Then in point number 10, we have in case of drunkenness. In case of drunkenness, person should not be examined and blood, urine, breath should not be collected without his written consent. So in case of drunkenness, all these things should be taken into consideration. If the person becomes unconscious, incapable of giving consent, examination and treatment can be carried out. If the person becomes unconscious or incapable of giving consent, examination and treatment can be carried out. So it is self-explainable point. Person can be examined without consent if requested by sub-inspector of police. Then point number 11, it says under section 87 IPC, a person above 18 years of age can give valid consent to suffer any harm which may result from an act not intended or not known to cause death or grievous hurt. Section 88 IPC, it says a person can give valid consent to suffer any harm which may result from an act not intended or not known to cause death, done in good faith and for its benefit. Under point number 13, under section 89 IPC, a child under 12 years of age and an insane person cannot give valid consent to suffer any harm which may result from an act done in good faith and for its benefit. So, a child under 12 years of age and an insane person cannot give a valid consent. Then, consent from parent or guardian should be taken. If they refuse, then the doctor can't treat the patient, even if to save the life of the patient. So, it should be noted. Then loco parentis. There's a term called loco parentis. What does it mean? It says that in an emergency involving children, when their parents or guardian are not available, consent is taken from the person in charge of the child. For example, in case of a school accident, the consent can be given by the teacher in charge or the person in charge. Then the point number 14, it says under section 90 IPC, a consent can be given by a person under fear of injury or due to misunderstanding of a fact is not valid. For example, if a person is drunken or insane or has a fear of injury, then they will misinterpret the fact of a consent. So that consent is not considered as valid. Consent given by insane or intoxicated person who is unable to understand the nature and consequences of that to which he gives his consent is invalid. Okay, then point number 15, it says section 92 IPC, any harm caused to a person in good faith, even without the person's consent, is not an offense. Example, if an accident occurs and a person needs amputation, then it should be done without the consent of the patient, uh, if and it will not be considered as an offense. Point number 16, section 93 IPC, it says any communication made in good faith for the benefit of a person is not an offense if it causes harm to that person to whom it is made. Then extension doctrine. Point number 17, it says extension doctrine. What does it mean? It means if in the process of any operation, consented operation, if the doctor discovers the conditions that had not been anticipated before, if any incident happens which was not anticipated before the operation begins, then which should endanger the life or death of or health of a person, if not corrected, then the doctor would be justified in extending the operation to correct them, even though no expressed consent was obtained. So in that case, the doctor should do whatever it is required to save that patient in order to correct that situation. So in that case, no express consent is obtained. Point number 18 says consent of inmates of the hostel is necessary if they are above 12 years of age. Then, if an inmate above 12 years refuses treatment and is likely to spread the disease, then he is asked to either leave the hostel or or if he stays, then treatment can be started without their consent. Point number 19 says when an operation is made compulsory by the law, then it should be done without the consent. Then the law itself provides the consent. For example, vaccination. Point number 20, it says a prisoner can be treated forcibly without the consent in the interest of the society. 21 point says consent given for committing a crime or an illegal act such as criminal abortion is invalid. Okay, 22, it says consent is not a defense in cases of professional negligence. 23, this 22 number point can be cleared when we will deal with the negligence. There are different types of negligence. We will deal with that in the later video. 23 number point says the nature of illness of a patient should not be disclosed to any third party without their consent, without the consent of the patient, of course. Then point number 24, it says for contraceptive sterilization, consent should be taken from both husband and wife. Point number 25 says the consent of one spouse is not necessary for an operation or treatment of the other. For example, if any case of it is only advisable in practical in cases where the operation involves danger to life or may destroy or limit sex functions or may result in death of an unborn child. In those cases only the other spouse's decision is considered or consent is taken. Otherwise, it is not necessary. Point number 26 says it is unlawful to detain an adult patient in hospital against his will. For example, if a person wants to leave the hospital against the medical advice, then it should be done. The patient should not be detained in the hospital against their will. Point number 27 says the donation should not be accepted if there is any risk of the life of a donor. Okay, in case of a donation, the consent is given by the donor, but if it involves the risk of the life of the donor, it should not be accepted. 28 number point says if any person has donated his eyes to be used after death for therapeutic purposes, the eyes can be removed only with the consent of the guardian or legal heirs. 29 number point says if any person has donated his body to be used for therapeutic or research purposes after his death, it is not binding on his spouse or next of kin. Question number 30, point number 30, sorry. It says the pathological autopsy should not be conducted without the consent of the guardian or legal heirs of the deceased. But in medical legal autopsies, consent is not required, and the doctor can remove any part of the body from the cadaver that is essential for the purposes of examination. So that's it. Thank you so much. We will deal with other topics of this chapter in the next video.